Welcome to episode 2 of Trial Recap, the State of Florida versus Charles Adelson, a new series that delves into the murder for hire of FSU law professor Dan Markel and the first trial where an Adelson family member is involved. This episode focuses on the numerous pretrial motions that were filed in the final weeks before Charlie's trial that began in October of 2023. As I mentioned in episode 1, these pretrial motions generated a bit of last-minute drama, which we'll cover here. September 22, 2023 was the deadline for the state and the defense to file their final witness and exhibit lists as well as any final pretrial motions. And there were a flurry of motions that were filed on this date. Specifically, they were a state's motion in limine, the state's motion to compel regarding defendant's impeachment and rebuttal documents, defendant's motion in limine, and the most important of them all was defendant's motion to suppress evidence derived from wiretap interceptions. Now, this motion was critical for the state's case because it involved the admissibility of those wiretap calls that were obtained in connection with the FBI bump that took place in April of 2016. And importantly, the scope of the communications the defense was seeking to suppress included not only those wiretaps, but the communications derived from those wiretap calls. Dolce Vita? Matsuri? We'll go over that in detail. We also had the state's petition for order to show cause regarding investigative subpoenas issued to Harvey and Donna Adelson. That's where there was a bit of drama. I'll cover that first. So the state's petition for order to show cause. On October 3, 2023, the state petitioned the court to issue an order to show cause regarding the refusal of Donna and Harvey Adelson to give testimony pursuant to investigative subpoenas served by the state in August and September of 2023. Now, the Adelson's attorney, Marisol Descalzo, informed the state that she did not believe that the interview subpoenas conferred the same use and derivative use immunity that a trial subpoena confers. And therefore, on October 2nd, she confirmed that Donna and Harvey Adelson would assert the Fifth Amendment privilege and therefore would not participate in the interviews that had been scheduled for October 3rd at the Miami's FBI office in South Florida. Now, you also recall that both the defense and the state had listed Donna and Harvey Adelson as witnesses for Charlie's trial on that September 22nd date that the final witness lists were due. Now, because of this refusal, the state filed that petition for order to show cause, whereby the state argued that the Adelsons had no constitutional right to refuse to comply with the state subpoena. Now, very briefly, under Florida's state immunity statute, a subpoena issued by the state confers use and derivative use immunity upon the individual. This means that anything that individual states while being interviewed pursuant to that state subpoena and any evidence derived from those statements cannot be used against that individual in the future. Now, I've done a deep dive analysis of use and derivative use immunity in a separate video, which I'll link above in case you're interested. Suffice it to say, the court agreed with the state's position and on October 4th issued an order to show cause requiring the Adelsons or their counsel to appear in person at an upcoming October 9th pretrial hearing. Now, the next day, October 6th, the Adelson's attorney filed a motion to reschedule the rule to show cause hearing, stating that Ms. Descalzo would be out of the country on business October 9th and requested that the hearing take place on October 12th. Now, that same day, in fact, an hour and a half after Ms. Descalzo filed her motion, Charlie's lawyers filed a motion to enforce the court's discovery deadline, arguing that the state should be precluded from interviewing the Adelsons because the interviews would take place after that September 22nd discovery cutoff. They conceded that the state had been trying to schedule the interviews prior to that discovery deadline, but this didn't matter because the interviews would ultimately take place after the deadline, and therefore they should be precluded. The state responded to the defense's motion the next day, reiterating that it had tried to subpoena the Adelsons back in August, and it wasn't until the September 22nd, the day of the witness list deadline, when Charlie listed Harvey and Donna on their witness list, that the state continued to compel Harvey and Donna to talk pursuant to the subpoenas. Specifically, the state argued that it would circumvent justice to allow Charlie to call witnesses, Donna and Harvey, at trial that they listed on the witness list deadline and use this deadline as a sword to preclude the state from knowing the contents of that testimony of those witnesses. Indeed, if these witnesses, Donna and Harvey, are going to testify at trial, they should be compelled to answer questions before trial as required by law, or they should be stricken on the defense's witness list. Now, the court agreed with the state and issued a written order on October 9th denying defendants' motion to enforce the discovery deadline, finding that such an order would effectively become a pretrial suppression order, substantially impairing the ability of the state to prosecute its case, while also permitting the defendant to call witnesses at trial who were first listed on that discovery deadline. Nice try by the defense, but the court got it right. Now, the hearing on the order to show cause was ultimately pushed to October 12th to accommodate the Adelsons' attorney's schedule. This was a fascinating hearing. At the outset, Judge Everett first addressed the Adelsons' attorney, Ms. Descalzo, and asked her if she was aware of the Florida rules of professional responsibility and the duty of candor to the court to disclose all controlling authority, including adverse authority. Now, what this means in layman's terms is that as an officer of the court, when you file a motion or a pleading, if there is controlling or mandatory authority, such as case law or a statute, even if it's adverse to your position, you must disclose it to the court. You cannot hide behind it.
In effect, with your motion to dismiss, you're arguing against a statute, Florida appellate law, and the United States Supreme Court. What is your basis in fact or law to make this argument?
Well, Your Honor, I have not read Belle's book, but just listening to what Your Honor has been saying, the case from the Supreme Court of 1964, I think is inconsistent with the Second Circuit opinion that I cited, which is much more recent, which states a similar fact, even though it's not state versus federal, it's federal versus foreign authority.
Then what you're citing to is not applicable with regard to the state's grant of immunity.
Understood, Your Honor, but we are not in the third DCA. I don't know if we're not in the third District Court of Appeals, so there might be the appellate court in this district might take a different view to what the Supreme Court case says. I believe the case of U.S. v. Castigar is after this 1964 Supreme Court case.
It is. It came in 1998. Go ahead.
Right. So I believe the Castigar case, which is also a Supreme Court case and talks about Fifth Amendment privilege, gives different protections. For example, under Castigar, in order to convey immunity, it has to go before a court. The court has to determine and compel the testimony. And once the testimony is compelled, Castigar gives the further protection of when you go before the court, if someone is indicted in the later proceeding, the state or the government, federal government, has the duty to prove to the court in a hearing that protection.
One moment, before you go on about Castigar, again, does that not deal with testimony that is being sought by a foreign entity, which would then implicate that individual's Fifth Amendment right?
Well, in Castigar, it was federal immunity. It was a federal court that compelled the testimony of Mr. Castigar, And the decision was that the provision of derivative immunity was sufficient to uphold the Fifth Amendment rights of Mr. Castigar, as long as these additional protections were put in place. And so, Your Honor, you're telling me that there's a Supreme Court case from 1964 that says the Florida statute is sufficient for protections under the federal government, and I'm saying, well, no, because Castigar gives additional protections, which is court compelled, and later the government has a duty to show the court how and where it got its information from, which is not a protection that's given by the Florida statute.
All right. Well, given the fact that I am going to find Section 914.04 Florida statutes is constitutional, and the authority of Bellador, which is binding on me as a trial court because it comes from the district courts of appeal, and Bellador specifically cites to Murphy versus Waterfront Commission of New York, which is found at 378 U.S. 52, and holds the constitutional privilege against self-incrimination protects a state witness against incrimination under federal as well as state law. Given all those layers of authority, this argument to dismiss the order to show cause, I'm going to find, is without merit and is denied.
Not a great start. Essentially, there was mandatory case law, both from the U.S. Supreme Court and Florida case law in the Second Judicial Circuit in Florida, that if you were offered immunity under a state subpoena, you cannot later be charged on some crime based on that testimony you provided under that subpoena. So Ms. Descalzo's argument that the testimony sought from the Adelsons would violate their Fifth Amendment right against self-incrimination was without merit. So accordingly, the court ruled that the Adelsons must appear for interview under the state subpoenas, which was then scheduled for October 17th. Now, Ms. Descalzo's arguments didn't end there. She next tried to ask for a stay, or a pause in the proceedings, ostensibly to appeal that ruling. Judge Everett denied her request for a stay. Now, based on the next part, I'm wondering if Ms. Descalzo didn't hear Judge Everett clearly.
Your Honor, I understand the court's ruling, but for the protection of my clients, I'm going to seek from you a stay of their testimony so that I can continue.
No stay is going to be granted. If your clients are not going to comply from here, we are going to move into contempt proceedings.
Understood, Your Honor. I have to speak to them before I decide. Your Honor, if you're not going to grant me a stay, and you're going
well, there's no need to keep stammering about the stay. The stay is denied. From here, are you going to produce your clients to testify pursuant to the grant of immunity, or I'm going to issue a writ of bodily attachment to bring them to Tallahassee, and we will have contempt proceedings here in Tallahassee?
No, Your Honor, I will produce them.
Now, the drama didn't end there. Judge Everett then turned to the defense and the state and asked for their comments. This is when Charlie's attorney, Daniel Rashbaum, decided to re-argue his motion to enforce the discovery deadline, which again, the court had just denied. And Daniel Rashbaum then accused the state of engaging in gamesmanship.
Just for the record, I put them on my witness list after the state sought their interview. So it's a little bit backwards, right? They're justifying the interview, and look, we understand we ruled on our discovery motion, but they justified in their response the interview based on me putting them on the witness list. But I put them on the witness list only after they sought an interview. So, Judge, again, I'll take them off the list if they're not interviewed, right? But the reality is, Judge, this is an end around the discovery rules. They've had years to interview these people, and now on the eve of trial, instead of me being able to prepare my client for possible testimony, they're interviewing key witnesses in this case who aren't going to be called as witnesses. I told you, if they're not interviewed, I'm not calling them. 6 days before trial starts. So rather than be in Tallahassee prepping for trial, it's gamesmanship that now I have to stay in Miami and be here for these interviews. They've known about the Adelsons for 8 years. Mr. Adelson was arrested a year and a half ago, and they wait till now on the eve of trial to try to interview these people. It's not right. It's a blatant violation of the discovery order. We understand how you ruled, Your Honor, but the justification that I put them on my interview list, let me be clear, I'll take them off the interview list, off my witness list, if they're not going to be interviewed. I put them on there as a protection for myself to put them on there. So let me make sure I understand. I'm saying right now that I don't plan on producing them as witnesses.
I don't know if the state is planning on calling them. They've made no representation of that matter.
So is your ruling that if the state doesn't...
No, hold on, Mr. Rashbaum. My ruling is what was stated in the order denying the motion to enforce the discovery deadline. With regard to Mr. and Mrs. Adelson at this point, they need to be produced for the interview on October 17th. If no one is planning to call them, then really from there, that moots the issue as to the trial. But for the interview itself, they are to be produced on October 17th.
The thing is, Judge, it's gamesmanship because the state doesn't plan on calling them. So they're trying to get an interview now on the eve of trial, frankly, to figure out what my defense is. That's why they want to interview them. They don't plan on calling them. Ask them right now. They don't plan on calling them.
Daniel Rashbaum's takeaway was that he'll just take Harvey and Donna off his witness list. But Judge Severett said, hold on, the state has a say too. And this is what the state had to say.
There's no chance they're going to call
Kappelman, Ms. Dugan,
Yes, Your Honor.
do you have any representations to make as to whether the Adelsons will be called?
Contrary to some of the pleadings that have been filed in this case, the Adelsons have never made themselves available for interview. They were sought to be interviewed shortly after the homicide. They did not make themselves available for interview. They have never made themselves available for interview. And only when I reached out to nail down the fact that they were going to invoke, did they begin this whole process by saying, oh, well, we're going to invoke for pretrial interview purposes, investigative subpoena purposes, but not for trial. So obviously that's not an acceptable result for the state. That's when I began to fear they were going to testify for the defense. And then they were listed by the defense. I thought I was clear in my pleadings that I anticipated they would invoke for everything prior to them being listed as witnesses on the defense witness list. Okay, so I think I laid that out. I wasn't trying to bootstrap in the interview by the fact that they were listed on the defense witness list, as they're now accusing me of. And I was seeking to interview them prior to that, seeking to either nail them down on their invocation or not. I don't know if I'll call them as a witness because they've never said anything. They've never been subjected to an interview. So it's certainly possible, depending on what they say, that I could call them as witnesses. They certainly are people that have relevant evidence to the case. Whether they'll provide it or not, I can't know until and unless they're compelled to submit to this interview pursuant to Your Honor's order.
Now, Judge Everett concluded that his ruling stands and the Adelsons must appear for the interviews on October 17th. Now, as a postscript, the state ultimately agreed to the defense taking Donna and Harvey off the witness lists. However, the state understandably wanted assurances from the defense and Charlie that he was knowingly and intelligently waiving his constitutional right in calling Harvey and Donna as witnesses in his case. Therefore, the state, the defense, and Charlie himself signed this document setting forth Charlie's waiver to call Harvey or Donna either in his case or in rebuttal. Pretrial motions. The rest of the pretrial motions were primarily addressed at a court hearing on October 9, 2023. However, the ruling on that granddaddy of them all, the defendant's motion to suppress, was reserved at this hearing. We'll get to that written order on the motion to suppress shortly. Now, the rulings that occurred on that October 9th hearing. Now, with respect to the state's motions, the state first withdrew its motion to compel regarding defendants' impeachment and rebuttal documents as the parties had worked the matter out amongst themselves. Regarding the state's motion in limine, it addressed a number of matters. First, the motion sought to limit any evidence concerning Luis Rivera's gang affiliation or prior bad acts concerning his federal case for which he was serving time. The court granted this, although ruled that the defense may explore Mr. Rivera's potential bias in connection with the concurrent state and federal sentences he was serving. The state also sought to limit any testimony regarding unrelated bullets that were recovered at Premier Health and Fitness, which was the gym where Dan Markel had worked out just prior to his murder. The court granted this as well. The state further sought to limit any evidence regarding Luis Rivera's mental health, as well as any allegations of domestic abuse between him and the mother of his child. The court also granted these. The state also sought to allow the presence of investigator Jason Newland of the Office of the State Attorney during the entire trial and not be subject to the rule of sequestration. They also sought for the allowance of the use of headphones for audio evidence, both of those which the court granted. The court further allowed the state's use of the court reporter's transcript of the Dolce video audio as part of a composite demonstrative for the wiretaps. Finally, the state sought a ruling on the admissibility of a number of those wiretap calls, which the court granted subject to the court's future ruling on defendant's motion to suppress evidence derived from wiretap interceptions. Now, regarding the defense's motion, the court denied defendant's motion to use a juror questionnaire. Regarding the defendant's motion in limine, the defense sought a number of exclusions, including the enhanced Dolce video audio itself, which the court denied, the opening statement in the enhanced Dolce video recording, which was this.
If they had any evidence, they would have already knocked under the court. You can just follow it, even if they plugged it, even if they plug your whole car, they'll get it. But even if they plug your phone, okay, you're it's on without any. So my point is, how do you get people to talk? You put a smoke grenade, and then you get all the cockroaches to run out. There's smoke in the house, smoke in the house. And everyone's running, everyone's talking, and you throw the smoke grenade. What do you think?
The court denied this and ordered that the opening remark is admissible, although the defense may request a limiting instruction for the court's consideration. The defense further sought to exclude the state's use of a transcript of the enhanced Dolce Vita recording, which the court did grant, meaning that no such transfer would be allowed. The defense also sought to exclude certain statements by Jeffrey Lacasse, who was Wendi Adelson's boyfriend at the time of the murder. The statements they sought to exclude were that Wendi told Jeff that Charlie had bought her TV as a divorce present because it was cheaper than a hitman. Wendi told Jeff that Charlie looked into the possibility of hiring a hitman to address the Markel problem. Wendi told Jeff that Charlie described a dinner that he and Wendi shared following Dan's murder, and he described it as a celebration, and that Wendi told Jeff that Charlie kept large amounts of cash in his home. The defense argued that all of these statements were inadmissible hearsay. The court granted the motion. Although stay tuned for a future episode where I explain how some of those statements ultimately managed to get in. The defense also sought to exclude Dan and Wendy's divorce files, which the court denied. The court did grant the defense's request to exclude testimony concerning a call that Charlie's prior counsel had to law enforcement following Catherine Magbanoa's arrest. Finally, the defense sought to exclude testimony from June Umchinda, Charlie's former girlfriend, that Donna Adelson once complained following that FBI bump that she, Donna, felt that Dan Markel was haunting her from the grave. The defense argued that this statement should be excluded as both hearsay and relevance grounds. The court agreed with the state that the statement was not an admissible hearsay, and it wasn't being offered for the truth of the matter asserted. No one is suggesting that Dan is actually a ghost haunting Donna from the grave. The court allowed the state the opportunity to provide any evidence which would go to relevance to show that Donna's statement had bearing on Charlie's state of mind. The state filed its response, but the court ultimately found that the response was inadequate to show relevance and therefore held that June Umchinda's statement would not be admissible. Now note, in Donna's upcoming trial, the state should be able to argue that this statement is admissible as a statement of a party opponent. So now that leaves the biggie, the defendant's motion to suppress evidence derived from wiretap interceptions. The defense moved to suppress evidence gathered as a result of the orders authorizing wiretaps of Charlie and Catherine Magbanoa's phones in April of 2016, arguing that they were unlawfully obtained. Now, obviously, if this was granted, it would be devastating to the state's case. But even more importantly, the defense argued that not only should those wiretaps be suppressed, but also any evidence derived therefrom, including specifically the interception of Charlie's oral communications, which were separately authorized on April 20th, 2016, which was extended for an additional 10 days on April 29, 2016. Yes, you heard that right. Charlie's oral communications means the Dolce video audio recording, as well as the Matsuri audio recording. Now, obviously, suppressing the Dolce Vita audio recording would be devastating for the state's case, as this is an essential part of their case against Charlie, perhaps one of the most important pieces of evidence the state has. So let's go over the arguments the defense made in support of its motion to suppress this evidence. The first argument was that the information contained in the wiretap application was stale and therefore did not support probable cause for the interceptions. The defense argued that the state's probable cause justifying the wiretap order was based on events that took place months and even years before the applications were submitted on April 7, 2016. Examples of this stale evidence: the defense cited Wendi and Dan's divorce proceedings, Sigfredo Garcia and Luis Rivera's post-murder motorcycle and vehicle purchases with the hit money, Wendi changing the last name of Dan's children, Katie driving Harvey's black Lexus, and the transfer of the Lexus's title to Katie in January 2016. The defense argued these all occurred beyond the Florida Supreme Court's 30-day guideline, although they did concede at the time that the 30-day time frame is not a hard and fast rule. Recognizing that the state would likely argue that staleness should be liberally examined when there is an ongoing conduct and a continuing conspiracy, the defense diminished the fact that Katie was receiving ongoing cash deposits and paychecks from the Adelson Institute. The defense also attempted to downplay the pen register and toll records included in the wiretap applications, which reflected the numerous calls made between Charlie and Katie and Charlie and Donna. The state had cited that between Charlie and Katie, just in the 30 days prior to the application, they had had 34 calls. And between Donna and Charlie, again 30 days before the application, they had had 54 calls. The defense argued that it's normal for mother and son to talk frequently, which may be true, but how do you explain almost as many calls during that same time period between exes, Katie and Charlie, who had been long broken up? The second argument that defense made in support of its motion to suppress the electronic communications was that the orders for the wiretaps failed to satisfy the necessity requirement. Under the necessity requirement, law enforcement generally must pursue other investigative procedures before resorting to invasive electronic surveillance. Now, although the defense concedes that the necessity requirement is not an exhaustion requirement, meaning that law enforcement doesn't have to do every other procedure before resorting to wiretaps, they essentially argued that they should have. They argued that the state should have pursued additional pen registers to accompany the bump instead of the wiretaps. They also alleged that the state should have conducted additional surveillance of targets other than Sigfredo Garcia and Katie Magbanua. They further argued that the state should have interviewed additional suspects, including Luis Rivera and Katie Magbanua. They also claimed that the state should have executed additional search warrants, such as on Charlie and Katie's cell phones or their residences. The defense also argued that since the state already had probable cause regarding Sigfredo Garcia and Luis Rivera to commence a murder prosecuted, they shouldn't have resorted to wiretaps on Katie and Charlie. The state responded strongly to these arguments by the defense. First, they argued that the information in the probable cause affidavit in support of the wiretap applications were not stale for a number of reasons. First, at the time of the wiretap application, Katie was still being paid by the Adelsons for her role in the murder and subsequent silence and cover-up. They also noted that the transfer of the Lexit had just occurred on January 23, 2016, just 2.5 months prior to the application. Indeed, the money, communication, and preferred treatment of Katie by the Adelsons family was still fresh and ongoing at the time of the application. The state continued its argument by citing precedent for the finding that when there's a continuing pattern of criminal activity is alleged in a search warrant affidavit, the issue of staleness must be examined more liberally. As this enormous investigation efforts were ongoing, the state argued that probable cause was more than suffice in this case. As to necessity, the state argued that the wiretap application set forth very detailed information on the investigative efforts that had been undertaken already and the reasons why other procedures would have failed. For example, the state noted that further surveillance of Katie and Sigfredo would not yield any additional information since they were living together and had a family. Without knowing the actual content of the communications, additional surveillance would be non-productive. Likewise, the argument that additional pen registers should have been used was without merit because law enforcement already identified the pattern of communication between the co-conspirators. What was missing was the content of those conversations. The state further argued that the defense's downplaying of the concerns with interviewing potential suspects ignored the very real concern that any such interviews would likely result in the individual tipping off the others involved in the conspiracy. Moreover, searching Charlie or Katie's residences would not have been productive since there would unlikely to be any physical evidence in those locations 2 years after the murder. Now, as stated, the stakes were high with this motion to suppress. For the defense, if it's granted, this would be a huge win, as the wiretaps and Dolce Vita recording are some of the strongest items of evidence against Charlie. This would also be devastating for the state's case. Now, ultimately, the court issued its written order on the defense's motion on October 16, 2023. The court denied the defense's motion. First, the court disagreed that the information used to justify the wiretap application was stale. The fact that this case involves both a pattern of ongoing criminal activity, the overwhelming incentive for the alleged conspirators to conceal evidence, and the existence of an ongoing investigation was compelling for the court. Also important for the court was that the wiretap was seeking fresh evidence of a crime with no statute of limitations. Murder has no statute of limitations. All of those factors weighed in favor of finding that the information in the wiretap application and accompanying probable cause affidavit was not stale. Likewise, the court found that the wiretap application did not fail the necessity requirement. The court noted that the application provided thorough detail on how other investigative measures had been exhausted, and therefore the wiretap was necessary to obtain evidence related to the crimes under investigation. Moreover, the court held that the state was not precluded from securing evidence beyond probable cause. Indeed, in order to develop an effective case, the state needs to obtain evidence beyond that. They need to obtain evidence establishing guilt beyond a reasonable doubt. Therefore, the defense's argument that the state should have simply stopped its investigative measures and therefore not sought that wiretap order once it had probable cause to charge one or more of suspects was without merit. So with that, the state and the defense's final pretrial motions were resolved. Next, we move on to jury selection, or voir dire. The defense gambled big time in this regard. We will cover that in the next episode of Trial Recap, the State of Florida versus Charles Adelson.